Hello everyone, welcome. Today, myself Shubham Tomar, and I'm taking the topic of judiciary. So this topic is quite relevant for this year examination because it was in news, and there has been the case of Justice Verma, that is of Delhi High Court, who has been charged with corruption, and proceedings have been going on regarding him. And there may be a case that he may either resign, or there are two provisions: either he may resign or the procedure for impeachment of him will be taking place. But I think the first one will be there because अभी तक ऐसा हुआ नहीं है that कभी भी के किसी को इम्पीच किया गया हो. ऐसा 4 बार हुआ है अभी तक, 4 केसेस हुए हैं अभी तक जिसमें कि इम्पीचमेंट का प्रोसेस चला, बट इम्पीचमेंट का प्रोसेस पूरा नहीं हो पाया. उससे पहले ही जज साहब थे उन्होंने रिज़ाइन कर दिया. तो दिस में भी द केस, बट हमारे लिए क्या काम की चीज़ है वो हमें देखना पड़ेगा. वी नीड नॉट टू गो इन टू डिटेल्स ऑफ द न्यूज़ क्या है. तो काम की चीज़ ये है कि जुडिशरी से मैं अभी आपको डिस्कस करूँगा. सो क्वेश्चन जो है वो मेंस में, जैसे कि अभी हम देखते हैं तो ये मैंने आपके लिए मेंस के क्वेश्चन लगा रखे हैं. तो 2024 में पूछा गया है, 14 में, 21 में. तो हाई प्रोबेबिलिटी है कि इस साल भी क्वेश्चन आएगा बिकॉज जुडिशरी वाज इन न्यूज़. और बेसिकली दे मे आस्क अबाउट द ट्रांसपेरेंसी विच इज़ देयर, और दे मे आल्सो आस्क अबाउट द नेजेक, नेशनल जुडिशियल अपॉइंटमेंट कमीशन, विच हैज़ बीन देयर, क्योंकि उसे भी 10 साल हो चुके हैं. So these are the case, so that's why I am covering this topic. And moreover, this is very much relevant for your prelims examination 2026 also, because there has been the case that after 2022 they have not asking question from judiciary. So there is high chances that this year, that is 2026, they may ask question from judiciary. So let's come to the topic. So tell me why we need judiciary. See, जुडिशरी एज वी ऑल नो इज़ अ थर्ड पिलर, वो तीसरा पिलर माना जाता है अपनी डेमोक्रेसी का. और किसी भी डेमोक्रेसी को सर्वाइव करने के लिए ये ज़रूरी है कि चेक एंड बैलेंसेस होने चाहिए. तो उस चेक एंड बैलेंसेस के लिए कहीं ना कहीं जुडिशरी कम्स इनटू द प्ले. तो जैसे कि आपको नॉर्थ कोरिया का आप एग्जाम्पल लीजिए. नॉर्थ कोरिया खुद में, या चाइना का ले लीजिए, वहाँ पे डेमोक्रेसी है बट इट इज़ नॉट एट पार विद अदर डेमोक्रेटिक कंट्रीज ऑफ द वर्ल्ड. सो व्हाट इज़ द रीज़न? बिकॉज ऑफ द इनएफिशिएंसीज और द that the judiciary is not having there. So what is the, how can we see that inefficiencies are there? So the main thing is the constitutionalism, which we have to say that whether the country is following the constitutionalism or not. So I'll discuss what the thing of constitutionalism. So constitutionalism is basic the limitation of the government, limitation of government power for citizens right. So what do you think, which will the organization which will have the limitation on the power of the government or the executive, you can say? So only there is one organization, that is the court of the country, court of the land, whether it is Supreme Court or High Court. So here to establish, so what we get into from it, that to establish constitutionalism, the most priority is the judiciary should play its role which has been assigned to it. So if we have to see a country is having the better form of constitutionalism or not, the first and foremost priority is whether the judiciary is functioning its role in the more efficient way or not. That is the thing which we have to see, and that's the necessity of judiciary in India. See, judiciary also there in countries like Bangladesh, Pakistan, but still they are not good democracies. So we can say that having legislature and executive is not the thing which will make you a good democratic country. So here the judiciary plays a role. So judiciary is a vital organ to establish the constitutionalism or the basic framework of democracy in a country. So this was the question. Even in the prelims, this sort of conceptual question comes regularly. So that's why I have given so much of details. See, anything which I will be explaining is not of irrelevancy, and there has always been a linkage with the PYQ which has been asked. And let me show you first the PYQ also. So this is the prelims PYQ. See, which of the following is the custodian of the constitution? So here, custodian, you can say the same thing which I was explaining. So Supreme Court is the custodian, because even the CJI took the oath of the that he will be aligned with the constitutional values and he will protect and pretend the constitution of the country. Second, what other I was asking? See, same question. Which of the following factor constitute the best safeguard of liberty in liberal democracy? So best safeguard of liberty, but here the thing is that most of the people have marked is a committed judiciary, but committed judiciary is a negative concept in itself. See, committed bureaucracy is a positive concept. Committed, anything which is committed is like when judiciary is committing, it is aligning with the government policies. But when a court or any apex court of the country is aligning with the centrality of the theme of the government, it's not good for the country. See, the betterment of the society is the need of the hour for the Supreme Court. But here, if it is aligning with the government and its policies, then it is not best safeguard for liberty in a democracy. So most of the people had marked it committed judiciary, but here the separation of power is the answer. So separation, when there will be a pure separation of power between judiciary, executive and legislature, then the liberty of the individual can be safeguarded, and that work will be done by the court of the country. So that's why I was discussing that thing. So now constitutionalism we have discussed. Indian judiciary serves a crucial player, upholding the same thing which I explained, constitutional, interpreting the law. So Indian judiciary are having three main functions. First, the protection of the constitutional values of the country. Second is protection of the rights of the citizen of the country. Third is protecting the federal setup of the country and interpreting the constitution wherever necessary for the betterment of the country. Then independence, fundamental role, this we have discussed. So what is the structure of judiciary? So structure of judiciary, there are two types of structure of judiciary. One is the judiciary which structure which we are following, that is the integrated judiciary. So we are having integrated judiciary, the Supreme Court, High Court and District Court, they are all integrated. If the case is there, okay, so we'll take what if the case is there with the district and subordinate court and you are not being abiding with the judicial and you are not happy with the justice which have been delivered, then you can go to the High Court. In the same way in the Supreme Court, but that is not in the case in other countries like USA. They are not following the integrated judiciary, they are a separate judiciary system. So they are having a federal judiciary. Federal judiciary is the central judiciary, and its main function is to interpret the constitutional things which are there in the country, and you cannot approach directly, the citizen cannot approach directly to the federal court of the USA. But if the law has been there in the there is crime that has been taken place, so you are having the court in the district level, and you can approach there only. There is no provision of directly going to the federal courts, and federal court does not take into consideration the cases which are there for the states or civil or criminal cases. They are mostly taking the cases related to the central one. So this is the case. So structured judiciary we have discussed. Should we discuss the article also? Wait, it is established in the article Article 124 of the Constitution, which provide the constitution of the Supreme Court at the apex levels and sitting in the Delhi, and other than that, it is also contributing. 124 is also an appointment of judges. The appointment of judges is also there in 124, and it has been there in Article 124 that there shall be a one CJI and minimum 7 other justice of the Supreme Court, and whatever the judges which have been assigned by the Parliament of the country by passing the appropriate law. So presently it was like 33 plus 1, that is 33 judges plus 1 CJI, so total 34 judges. It was 30 judges that was the case, but 3 years back they have added 3 more judges because of the pendency of cases are more. So this was the case. In case of High Court, it is in Article 241. So there every state will having its own High Court for taking the cases which are coming from the lower courts, that is in Article 124, and then there are district and subordinate courts that are Article 261 to 272, something like that. So it was there. Next. So this I have discussed what are the functions of the judiciary: interpretation of law, protection of fundamental right, dispute resolution, and what is the fundamental function of Supreme Court. The Supreme Court is court of record, and which are intra-state dispute resolution. These are the two main core functions of the Supreme Court, which is there mentioned in the Constitution. Other than that, all are not the primary function of Supreme Court. If the question will be asked in that manner, that what are the primary function of the Supreme Court, then it is the court of records. Court of record means whatever interpretation of the Constitution will be taking place in the country, or whatever the precedents or what are the judgment the lower courts are giving, it will take into consideration the record of the cases which are there in the Supreme Court. The Supreme Court is acting as a interpreting court for other courts also. Other is the interstate disputes, whether it is interstate water dispute, interstate land disputes, whatever will there, the Supreme Court will have the final authority for that thing. So this is the basic word for Supreme Court. Then we'll go judicial review. Now we will come to another topic, that is the judicial review. I think things are clear till now. So judicial review has been there. We'll give the legal perspective what is there. That is Article 13 2 and Article 32 226. So these are the article which gives the power to the Supreme Court to judicial review any of the act which has been passed. So act is also there is been the clash whether what is law. So law is there in Article 13, that any law which has been passed by the Supreme Court have to be prove its legality, or it should, and as the case has been given in the Keshwanand Bharti case, that it should not violate the basic structure of the Constitution. That is the different perspective. But here the thing is that judicial review by any of the court like Supreme Court or High Court is there for constitutional supremacy, or through which its checks and balances are established in the country and invalidation of the law take place. This is done. So now we'll come to the judicial appointment. So there has been the evolving procedure in the fourth. This simple concept about the question have been regularly asked from this. We can just get a brief overview of it. So first the SP Gupta case of the Union of India. So here they have given you can note it down here. SP Gupta case. Here the concurrence article 124, which is avoid appointment. Which is about appointment of judges of Supreme Court. Here it is there that there should be a concurrence of president, or can say government or executive, you can say. So the main issue here remain the interpretation of the word concurrence. So initially they have given a narrow interpretation. They were like concurrence is just that you have to take the authority from the government, and if government is not supporting the appointment of any of the judge, then it will be not taken into consideration. That judge will not be appointed. So here it is the narrow interpretation, and concurrence here means that government approval. Later on, the doctrine evolved, and the Supreme Court Associate on Records and Association of India, Union of India case 1993, that concurrence word now have a broader interpretation. and it gave rise to the system of collegium in the country. So here the concurrence, initially they were saying that concurrence is like you have to take the permission of the government, and government is not binding with the appointment, then it will not be taking place in the country. But in this Supreme Court Association Records Association, here they have taken the view that concurrence is just, you have to just take a viewpoint of the government, and it's not binding on the court to have that sort of appointment on the basis of the government decision which has been given. So here the collegium system have evolved, and there what the collegium was, the CJI and two other judges. So CJI and two other judges were there from Supreme Court, which will take into consideration the appointment which will be taking place. Here the two judges will be the senior most judges of the Supreme Court. So they will take the decision on what are the people which will be appointed in the high courts and the higher courts of the country. Regarding appointment, there also, if you are having confusion, like there are two examination which is taking place in the country. One is the higher judicial services, and other one is the lower judicial services. So from only these two entries are there from where the judges of the country are being appointed in the country. So lower judicial services examination, as you all know, that is UPPCS, UPPSC and BPSC, RPSC. These state level commission are taking the examination for appointment of lower judicial lower judicial courts judges. So here they are, the DJ and all, they are appointed from these examination. Higher judicial HJC, it is higher judicial commission, higher judicial court, they are taking examination by the high court of the state. And here the thing which you have to see, like there has been case, it is like selection is like a army, the post will remain vacant if they will not find the suitable candidate for the post. So there has been a case in many of the states, like recently there is 4 months back the result came of higher judicial courts in of Odisha, and not a single candidate was found eligible for appointment for HJ, because they are directly appointing you to the DJ of the district judge, and they from there you will get, within 10 to 15 years you will be appointed to the high court. So it is like shortcut, like 10 to 15 years of your services will be cut it down. So it is that thing. And other thing, the reform which has been more of talked of, like all India judicial services, which was there mentioned in article 312 of the constitution. So that has been in the news, but still the government has not taken any concrete measures, and even judiciary is reluctant to having appointment from the all India judicial services, but it is there mentioned in the constitution. But the thing which you need to know, that it is like the exam will be in the same pattern like that of UPSC. So they will appoint by having the examination at the by national level by the UPSC, and but it is not there in the country. So this is the case. So we were there in SP Gupta case done, Supreme Court. Then third case is re-precedent reference case. So this is just a reference, and here the same thing has been reinstated, and they were like initially they were 2, now they have taken CGI plus 4 judges. So they have just increased 2 judges here, and now the total judges in the collegium become 5. And even if 2 judges are not in favor of an appointment of any of the judge, then the veto power will be there, and the judge will not be appointed. So this is the case with representative union. Then Supreme Court Associate on Records Association versus Union of India, that is the case in which NAJAC, National Judicial Appointment Commission, which was made by 99th Constitutional Amendment Act. So NAJAC, which was a body which was appointed by government in 2014 for the appointment of judicial Supreme Court judiciary members, that was formed, but it was struck down by the Supreme Court in Supreme Court Association in Records and Association case in 2015. So I think that thing is not relevant to see that what are the members which are there in the NAJAC, especially if you want to know that simple concept, but it will not be asked in the examination. So but the CGI will be there, 2 senior most judges will be there, the same that was there in collegium, and there are law minister will be there, PM will be there, law minister, PM, 1 CGI, 2 chief justices, and the 1 eminent person which has been appointed by for appointment of CGI by Prime Minister, Leader of Opposition, and the CGI. So this is the case. It is just you need to know, but it is not relevant because the act itself is not relevant. So here it is the case. So let's revise whatever we have read. Indian judiciary, what is constitutionalism, why the need of judiciary is there for reinstating the constitutionalism in the country. Then we have seen structure of judiciary, the integrated judiciary which we are having. It is different from the judiciary from USA and other countries. Then function of judiciary, we have seen Supreme Court, what is it, the court of record, and the inter dispute resolution, that are the main functioning of the Supreme Court, article 2214 there. Okay. Then judicial review, which is mentioned in article 13.2, article 32, 22, 26 for High Court, for constitutional supremacy, these check and balances, that may be relevant for a mains examination. You can pinpoint it 2-3 points, that what is the need of judicial review in the country and how it has helped country evolving from a colonial past to a democratic nation. Then what is the landmark judgment for the appointment? We have seen how there 124 article was there for appointment, and initially concurrence was the government approval, and later Supreme Court associate records, it was the broader interpretation that they have taken, and collegium came into place by this case, and there were CJ and 2 judges. Then 2 more judges were increased in the collegium by representative union. Then NAJAC was there. How was the appointment taking place in the judiciary? Lower judicial, LGC and HJC, State Public Commission taking examination. This we have discussed till now. Now the judicial independence. So why there should be independence of the judiciary, or we can say the separation of power will be there in the country, as the question we have discussed in the initiation of the lecture, that if there will be judicial independence, then the citizen right can be sacrosanct in the country and they can be saved. This is the case, and separation of power will be there, judicial accountability. This is the basic thing. So what are the cases? So issues, just you keep a broader issues in your mind. Case backlog, like around 5 crore plus cases back are pending in the cases. Other issue is the issue of under trials. Most of the people around, according to the latest data, 70% of the people inmates in the jail are under trials only, and in that the issue is that most of the under trials have already done more than half of their judicial punishment. They will get if they'll get into the cases issue. Then a large case backlog, that we already know, same thing is there. Getting justice is very hierarchical task, and we also know that Indian judiciary is like a judicial judge advocates paradise, because the constitution is written in that way that only advocates and their family members can know what the exactly written, and other people it's not easy to know, to exactly get what the exactly wording is there and what is the interpretation. Even the courts take a lot many years to interpret what exactly they have written, so they deliberately put that wording so that it will be a, you can say, elitist constitution, and even the only high class people who are having high command on English language can understand what's there in the constitution. That is the case. You need not to write these things in the examination, like this is just a normal viewpoint which I have given. So then bribery, delay, these are the basic things. Then next, this role, the same thing I think we have discussed. What is the role? Upholding constitution, maintaining democracy, citizens right, becoming having a court of records, whatever be there in the country, and commitment to justice. These are the things. So these are the relevant articles which you need to remember, which you can mention in your mains answer sheet, and which will fetch you good marks. And even if you are not fetching, like your computer is writing, so you should also write. So if there is like constitution of establishing of Supreme Court, it is under article 124. 214 is establishment of High Court. To remember in a simple way, you can take two outside and you can reverse it, 241 214. Okay, 214. Okay, and then original appellate jurisdiction of Supreme Court. So original is in 131. The original I have already discussed what is original jurisdiction, interstate disputes and court of records, that is there. and appeal it is with the, if you are not happy with the judgment which has been given by the high court, then you are going to the supreme court, that is the appellate jurisdiction, from the lower court to the higher court, that is the high court to supreme court. Or then article 129 to 202 and 215, this same thing which I have discussed, the court of record, that is mentioned in article 129 for supreme court and high court. One question may mostly asked in prelims, that is high court is also the court of record. So it is correct, high court is also the court of record. And the court which is the court of record is also having the power of contempt of itself. Contempt, you already must be knowing that the contempts are two types of contempt: civil contempts and criminal contempts. Civil contempts are willful disobedience, like court has given some of the jurisprudence and you are not following that, that is a civil contempt. It's any order they have given and you are not following, that is a civil contempt. But criminal is like you are delaying the justice, you are delaying what is the, you are, whatever the court have given the precedence, you are not following, and also you are obstructing the justice system, and you are openly criticizing court in the media and everywhere, that is a criminal thing, criminal contempt. And 141 is a law declared of Supreme Court binding. 141 states that there's the whichever be the jurisprudence given by the Supreme Court is binding on all the courts. Article 136 is there, which is the special leave petition. That is, you can directly appeal to the Supreme Court by having the special leave petition if any of the issues of concern is there. And curative petition is for the petition where court decision have been given, and after the decision you can review the decision, you want to review the decision by the court and you are not happy with the decision, then the curative decision taking place. This is the most relevant article, article 142. Article 142 is the article which makes the Indian Supreme Court one of the most powerful Supreme Court of the world. Article 142 gives the power to doing complete justice in any case or matter pending before it. So you can give the example of article 142 in the Supreme Court banning the firecrackers and Diwali. So by using this power they have banned, because they are the sole protector of the rights of the citizens according to them, but they are not reforming in themselves, but they are reforming the whole society. So this is the thing, अपना घर में सफाई नहीं करनी बट पूरे दुनिया में सफाई करके चलना है, that is the thing with Supreme Court of country. But still we have to see complete justice. सफाई का मतलब है रिफॉर्म से है, अपने यहाँ रिफॉर्म नहीं करना, nothing like that. And article complete justice. So what I am discussing the cases, okay, other cases like liquor ban was there within the 500 meter of the road highways, that is also the under the complete justice they have used the power. Vishakha guidelines, you can say Vishakha guidelines which are given in 2013 for prevention of women from sexual harassment at workplace. So that was under article 144, that is the complete justice, they have given those guidelines. These are the articles. Judicial review, we have discussed activism, active role of court, protection rights, basic points, rates of discussion. Okay, then come the PIL. SN Bhagwati was the judge who had given the PIL in the country. Basically the thing is that if your rights are violated under SLP, you directly can approach the court, no other person can approach on your behalf. But here the case is different, PIL is there. It was not there in the original constitution, but it came into the considerance in the country in 1982 as Sumera Khatun versus Union of India case, in which it came into the legislation. In that basic difference between PIL and SLP, I have discussed SLP, your rights are violated, you go to the court, that is SLP. And for PIL is like anybody, like if there is pollution in your area and you see that public human rights are violated because of it, or environmental rights are violated, so you approach the court or you approach on behalf of somebody else, that is public interest litigation. So legal mechanism to public to seek justice. And misuse of personal gains, these are the empower marginalized court signal PIL to misuse. Okay, this is the case. So these are the cases which has been there because of PIL. Vishakha guidelines that I have discussing. SP Gupta, which is scope the expanded the scope and allowing broader use of justice. Then MC Mehta was the environment thing, which is the environment protection, public safety, and according to this case, they have given this the human rights under Article 21. Indian Council for Environment introduced accountability of pollution and environment damage. So all the pollution related cases which are there, or all the human dignity related cases, or any youth cases, youth that all are under the PIL only. These are the evolution. Initially Hushana Khatun was the state of Bihar case, then SP Gupta, PODR, and initially So this was I was talking about Tana Khatun. So this was basically about the under trials which were there in the courts, and according by this case, around 40,000 sorry 40,000 under trials had been released because of this case. In PIL, what generally happens that if you are filing of for certain rights, the rights of under trials, so only this will not apply to only to you that you are filing. It is applied to whole of the country in the unisum. So all the under trials which are there in the country will be released, with this case. Then came the SP Gupta case. So this was the same case of locus standi they have established. Locus standi, the same thing which I was saying. Locus standi is that it's not the only your rights will be there, other rights will also be taken into care, and if you are given the positive judgment, that judgment will have an inculcation on other rights of the people also, and it's also institutionalized the procedure of PIL. Then comes the UDR versus Union of India. The same thing, legal movement, they have given same jurisprudence, it is nothing difference here. Or here Sunil Bhattar Delhi administration case, here Supreme Court has given the concurrence that they can so modo take into consideration also the cases which are relevant for the environment and judicial interpretation of the country, and they so modo take the cognizance of any of the cases which are there for protecting the public rights and being a human under Article 21 of the Constitution. So I think the slides are completed and we have discussed most of the important aspects. These are the questions which has been asked in mains. Disability, greater responsibility, women, higher judiciary ensured, diversity, equity, inclusion. The same thing which I was discussing, the reform which are needed in the judiciary. For the first reform is the appointment reform which should be taken place. Second is the reform regarding the transparency. Third reform is the about the inclusiveness. So you just prepare all the reform areas of judiciary, and your judiciary will be almost prepared. Like they'll most probably ask question from this lines only. So you already know that from Supreme Court till now only two women judges have been there who admit. That one is the Indu Malhotra, and another one was there who were appointed in the Supreme Court. So this was the case that desirability. Why desirability? Here you will give the data that till now from the independence there has been two judges who have been appointed to the High Court, and most of the cases regarding crime are against women only, and when women are not in the other sides and they are not listening the cases, then how can you expect that judiciary will be performing at par with what is needed? So this is the introduction which you will give. In the high judiciary ensured diversity, equity, inclusiveness. So the same thing, the democratic principles which are there, that should not be only for the citizen of the country, but should also need to be followed by the judiciary of the country. And Article 15, equal representation. Article 16, equally appointment, representation, appointment. Same should be followed by the judiciary. So here you can give this thing and you can explain it in 10 marks, 2 pages. Second question is starting from basic proactive instrumented India development, thriving democracy. See, here you will give a broader outline of what are the basic structure doctrine, where it emerged from Keshwanand Bharati case 1972, and then how it proactively role in ensuring India's development, and how it protected India and make it a thriving democracy by judicially taking into consideration the laws which has been passed by the parliament, and they are reviewing each and every law, and major law you can also discuss which have been delegated by the High Court and Supreme Court of the country, which are been struck down. So then in light of evaluate the role played by judiciary in achieving ideas of democracy. There then in the third page, second and third page, you will discuss the judicial activism in achieving the ideas. What are the ideas of democracy? Equality, liberty, fraternity. So these are the ideas of the democracy, and how judiciary played its role to establish them in the society. Simple, straightforward question. Nothing like you have to be in the other side. Explain the reason for the growth of PIL. Is here you will discuss the same thing. Evolution of PIL. Hussain Khatun you will discuss. P.N. Bhagwati was the judge who had given the jurisprudence of PIL. From here till S.P. Gupta to Sunil Batra, that is the suo motu cognition you can take. Here you will discuss the evolution and why there is a growth of PIL, because there is a human rights violation taking place in the country. So there has been a growth of PIL, and as the Indian Supreme Court emerged the world most powerful judiciary, and it is because mainly I have discussed according to the Article 142, which gives the ultimate power to the Supreme Court to do complete justice in the country, and PIL comes under the category of Article 142 only. So this here you will discuss Article 142 and how it makes Indian Supreme Court word most powerful judiciary that they will discuss, but take into consideration most of the articles, most of the cases which has been there regarding this, and you use the legal language which is there in the constitution. Like if you are discussing article 142, don't say that 142 says like that. Discuss as 142 pertain itself the Supreme Court the ultimate authority to establish the justice in the country, and for it has the power to do complete justice in the society. So this way therefore I suggest you not to refer any of the book for this article. Reading this article, directly go to the constitution and make use of the language of the constitution in your answer, and that will make you to fetch more marks in comparison to other people. This is the way you can go. Prelims question, I think we have done this question. This we have done. Gram Nyayalaya. So as per the act, Gram Nyayalaya can hear only civil and not criminal cases. This is wrong. Gram Nyayalaya can also listen to the criminal cases, criminal and non-compoundable. The act allows local social. This is, so first is wrong, second is correct. This thing is not coming in the slide itself, so we'll take the here only. And the third, in India, judicial review implies. So judicial review, you know, the power of the judiciary to pronounce upon the constitutionality of law executed. This is the judicial review. This straightforward question. Other way of Constitution of India, provision, limitation, or provision contained in the ordinary law cannot act as provision limited in the constitutional power. It could mean which of the following. Supreme Court not consider exercise in the event of grave the decision taken by section. Supreme Court of India not consider exercise whatsoever by law made by the Parliament. So in the event of grave financial crisis in the country. So this is the answer. The Supreme Court. Supreme Court of India is not constrained in the exercise of power made by the Parliament. This is the answer. Third one is the motion to impeach a judge of Supreme Court cannot be rejected by the Supreme Court. And this is the question. The motion of impeach a judge of Supreme Court cannot be rejected. No, Constitution of India denies. So first is correct. Impeachment cannot be rejected by Speaker of the Lok Sabha. Supreme Court of India defines and gives details what concerning incapacity improvement. Though no, Supreme Court doesn't define anything. So second is wrong. 2 is wrong. Then third, details of procedure of impingement of this are given in the judges inquiry. This is correct. This is given in the judges inquiry act. Let's see the fourth. The motion of impeachment of judges taken up for voting. The law requires the motion to be backed by each house of the parliament, supposed by a majority of total membership of the house, and what knows. This is also correct. So 3, 4. And first is the constitution defines and motion to impeach a judge of Supreme Court of India cannot be rejected by Speaker of the law. This is also correct. So 1, 3, 4 is correct here. Next we will see 7th question. In India, Legal Service Authority provides free legal services to which of the following type of citizen? So how we can say we can eliminate here like all senior citizens. So it might not be possible. Someone might be a Vijay Mallya, so he might not get the Legal Service Authority with the person who is having a property of so much of crores. So 4 you eliminate, 4 eliminated, then remained 2 is the correct. 2 is correct. Now we have to see between 1 and 3. So person with annual income of less than 1 lakh. Oh, that can be an answer. Third, member with an annual income of less than 3 lakh. I think this is the wrong question, the wrong answer. Member of OBC with annual income 3 lakh. I think it is a more limit they have given them more, and this is 1 and what is person with annual 1 and transgender income 1 and 2. 1 and 2 is the answer. Next question. With regard to Indian judiciary, consider the following statement. Any retired judge of the Supreme Court can be called back to sit upon Chief Justice. This can be done, no issue at all. You can call back the judges if there is required by the permission of the President of India. Yeah, High Court in India has the power to review its own judgment. Supreme Court, as we have discussed, High Court is also the court of record, so it can. But here the thing is that most of the coaching institute have given this as the correct answer, second one, but this was not taken into consideration as a correct answer by UPSC because the in Constitution doesn't mention that High Court is having the power to review its own judgment as the Supreme Court does. Not the same manner in the Supreme Court does. That's why second one is wrong. Only first is correct. On 1 is the answer. Pursuant to the report of HN Salin Committee, contempt of past. This is correct. Constitution of India empowers Supreme Court and High Court to punish for the contempt of themselves. Second is also correct. Third, Constitution of India defines contempt and criminal contempt. No, Constitution does not define what is criminal contempt. It is the Contempt of India Act 1981 which defined the contempt. So third is wrong, and 1-2 is correct. 1-2 correct. 4 is in India Parliament is vested the power to make law on contempt of India. Contempt of, yeah, and Parliament is having the power, and then under that power they have passed the Contempt of India Act 1861, I think it is the year. So 1-2-4, 1-2-4 is the answer. Next. Government law officer and legal firms are recognized advocate for corporate law, patent, or exclusive from legal. No, it's not the case. Even corporate lawyers, they are also lawyers. No, so they are recognized as lawyers or advocates. The first is wrong. Bar Council have the power to lay down the rules. This is correct. They have the power to rule the regulation and regulation. Second is correct. 2 is correct. So this way we have done it. The whole judiciary we have finished, and we have just done all the evolution which have taken place in judiciary. What are the cases related, and what are the PIL, SLP we have, because especially petition we have discussed on Article 136, PIL 142. What are the judicial accountability is there, judicial activism, and how it is like impacting the society in general, or evolution of PIL we have discussed. The cases in evolution which has been there, and all the mains question which has been asked from this topic that we have discussed. Along with that, the prelims question we have discussed. I think you must not be having any confusion now from this topic, and if you prepare this much, and then for this topic this is okay, and you will get your question from here. Okay, thank you.